Alright, Texas Code, Natural Resource Code, Title 3 for the Oil and Gas, Subtitle B for the Conservation Regulation for the Oil and Gas, Chapter 91, Provisions General Applicable, Subchapter A, General Provisions 91001, Definition of the Traffic Commission, with the Railroad Commission for the Texas Gas, with the Natural Gas, Oil means crude oil with crude petroleum oil, or X 1977. Section 91002, the criminal penalty, person willfully with a criminally negligence violates Section 91101 of the scope of the rule order permitted the commission issued under section incriminates the offense. The offense under subsection A of the section is punishable with a fine not more than $10,000 of each day of the violation is committed. Venue for the prosecution of alleged violation of this section is in court competent jurisdiction of the county, and the violation is alleged to have occurred Acts 1983. Section 91003 with additional enforcement authority and with additional authority specifically granted for the commission under the chapter the commission may enforce for the chapter any rule order permit for the commission adopted from this chapter in the manner subject for the conditions provided in chapter 81 and 85 of this code, include with the authority to seek and obtain civil penalties and injunctive relief provided by those chapters. If the enforcement authority in section 81054 with the Natural Resource Code issue for the Institute civil action alleging the violation of the NPDES permit with the issue under the chapter of the Attorney General may not oppose the intervention by the person who has the standing of the intervention provided by Rule 62, Section Rule Civil Procedure Act of 1993. Subchapter B, duties relating to oil and gas wells, section 91011, casing before drilling in the oil of the gas-bearing rock for the owner operative of the well building drill of the oil of the gas shall enclose the well with a good sufficient wrought iron shield casing with any of the materials meets for the standard adopted for the commission, particularly with the wells could be for the subject with corrosive elements, high pressure temperatures, in a manner too of the depth which exclude the surface of the fresh water from the lower part of the well with the penetrating the oil and the gas-bearing rock. Well is drilled through the first into the lower oil of the gas-bearing rock. The well shall be cased in a manner to do the depth of the well, but exclude the fresh water above the last oil or gas-bearing rock penetrated. The commission shall adopt rules regarding the depth of the well casing necessary to meet the requirements of Section 1997 Acts for the 2011 amended. Section 910115 casing letter of determination of the commission. They will issue the request for the applicant for the permit for the well with the drill of the oil gas-bearing rock. A letter determination stating with the total depth of the surface of the casing required for the well, section 91011, the commission may charge the fee with the amount of the determined of the commission with the later determination. The commission shall charge the fee not exceeding $75, and in addition with the fee required subsection B with the process required for the expedite with the layer of the determination. The fees collected under the subsection should apply for the oil gas regulation cleanup fund acts added in 2011 amended in 2013. Section 91012 of the waters and wells, and boring any well over the water. Any well of oil or gas, a person pierces with any cap of the rock with the geological formation with the manner with which will cause the flow of salt water or fresh water injurious into already bored oil well. Any oil gas deposit will probably result of the injury with the oil of the gas field. Already bored or oil gas well, the person shall abandon with immediate all work of the well, and the flow of the water cannot be cut, cease, be cased off, shall plug and fill with the well in a manner with the materials will stop the flow of the water. No well owner person boring a well described under subsection A with the section may remove the casing from the drilling well until the flow of the water is stopped either by casing off the plugging the well. The provision of the section applies only with the cap of the rock with the formation procedures for the depth of the below with the horizon at which the oil and the gas have discovered already. Section 91013 of the plugging, shutting of the wells and by any others. A, if the owner well described the subsection A of section 91012 this code neglects the refusal to have the well plugged and shut within more than 20 days after the written notice given to him with the owner operated adjacent to the neighboring land, may enter premises on which the well is located to have the well plugged if it is abandoned well shut off and not abandoned with the manner provided by the law. Notice by giving the owner of the well, either with the personally servant of the owner of the post to give the notice for the conspicuous place near the well. Reasonable cost of expense with incurred by the plugging and shutting of the well shall be paid by the owner of the well, may not be recovered at the depth of the like amount with recovered under the law in the Act 1977. Section 91014, petition of the restraint waive the petition with any of the penalties district judge if within time of the vacation shall hear the determine the petition with the file with the restraint of the waste of the gas with the violation of the subchapter may within issue of the mandatory restraining order with the judgments are necessary. The petition may be fulfilled with the citizens of the state, but it does not have to allege of the further financial interest of the position of the state of the natural resource of the possession of the common or all citizens of the state, as Act 1977. Section 91.015, prevention of oil for the operator contract with the drill pipeline company with the gas distributing company with the drill for the use for the produce oil for the gas pipe oil for the gas for the any purpose to use the possible precaution in accordance with the most proven methods established to prevent the waste for the oil, gas both for the oil and the gas drilling, producing, operating, storage, piping, and distributing its shell non-wastefully use for the oil for the gas, allow oil for the gas leak that escape from the natural reservoir well and tanks, container pipes, Action Acts 1997. 1977, Section 91.016, confining gas to original stratum. If the gas is located with the gas-bearing stratum known to contain the gas of the paying quantities encountered while drilling oil, gas, and the state of the gas is confined with the original stratum until it can be produced, used without waste. Gas-bearing strata shall be adequately protected from the infiltrating water. Acts 1977, Section 91.017, using gas in the open air with any person with gas light with the open air with the realm of the derrick shall turn off the gas no later than 8 a.m. each day if the lights are being burned are used and shall not turn the lights on and relight them between 8 a.m. and 5 p.m. The person consuming the gas used for the burners in the open air shall enclose the gas globes of the lamps. Acts 1977, the globe. Section 91.018, illumination. No person in co-partnership with the corporation may use the illuminating purpose of flammable lights. The use of the jumbo burners or other burners consumed with more than gas jumbo burners is not prohibited. That was an act in 1977. In Section 91.019, standard for the construction, operation, maintenance, electrical floor plan. Operators shall construct, operate, maintain electrical power lines, surface the well site with a surface facility that employed with the operation incident for the oil, the gas, development, and production, in accordance with the National Electric Code, published for the National Fire Protection Aid Association, adopted the Texas Commission Licensing Regulation under Chapter 1305 of the Occupant Code, added Acts in 2009. Section 91.20, electronic geological data with the Commission shall work with the cooperative with the appropriate state of the agency to study the value of electronic access for the geological data, show for the casing depths if necessary to protect the usable groundwater in the state. Acts in 2011. Subchapter C, standard gas measurement. 9151 with the title of the chapter should be decided with the standard gas measurement law. Section 9152 with the definition term of the cubic feet of the gas, standard cubic feet of the gas means the volume contained with the 1 cubic feet of its rate of the standard pressure base of the standard temperature. The standard pressure shall be 14.65 pounds per square inch. Absolute standard pressure shall be 60 degrees Fahrenheit. Condition of the pressure temperature for the differ with the standard of the conversion volume of these conditions. Standard conditions shall be made in accordance with the ideal gas laws corrected with the deviation. Acts 1977. Section 91.053, Commission determination. The Commission shall determine the average temperature of the gas produced in each of the oil gas field in Texas variable factor if necessary of the calculated the measured volume of the accordance with the ideal gas law of the variable factor for the correct with the deviation from the ideal gas laws of each oil of the gas field in the state. Section 91.054 of the notice of the hearing on a request for the interested person of the Commission shall give the proper notice to hold the public hearing of the before the making determination. Section 91.053 of this Code, Act 1977. 91.055 of the finding of the rule on making the determination. Commission promptly shall make the finding of the child adopt the reasonable field. The rule shall be necessary to effectuate the provision of the chapter. Acts 1977. Section 91.056, use of findings of the field rules. Any of the person may use the finding of the field of the rules for the Commission, any for the purpose of the subchapter. The finding of the field rules are not used to provide subsection A section to determine the volume. The finding of the subchapter, the volume is otherwise determine the corrective of the base for the standard cubic foot of the gas determined in section 91.052 of the Code, Acts 1977. Section 91.057, the method of reporting. Person required to report the volumes of gas under the laws of the state shall report the volumes on number of standard cubic feet calculated to determine under the provision of the subchapter 1977. Section 91.058, sale, purchase, delivery, or receive of the gas. Each of the sale of the purchase of the delivery of the receive of the gas on the state on the buy for or the half of the oil of the gas lease for the lease owner of the royalty owner of the lease. The other mineral interest owner shall be made with the gas shall be the measure for the calculated purchase delivered counted for on the basis of the standard cubic foot of the gas defined in the subchapter determined under the subchapter if the provision of the subchapter operate the chain of the measurement provided with the existing contract with the price for the gas included with the royalty of the gas provided with the contract show the judge for the compensate with the chain with the method of the measuring of the volume of the gas delivered under contracts if even the purchase of the seller does not so desire with the section 10 of the protected party for the contract with the existing October 4th 1949 for the total amount of the volume of the gas purchase required for the accounted for under the contract shall remain unaffected by the subchapter 1977. Section 91.059, constitutionality. The provision of the Section 91.58 with this code that any of the part of the section held with invalid with the unconstitutional for the code with the remaining with the portion of the subchapter shall become ineffective or inoperative. Section 91.061, civil suit. None of the provision shall be prevented with a aggrieved person for the maintaining civil suit for the damage of the county or counties in which the gas is produced, effective Acts 1977, Section 91062, applicability, certain provisions, none of the provisions, Section 91 through 58 through 61 of this code, effect apply with the purchase sale is made on the basis other than volume basis. Subchapter D, prevention of pollution, rules over the text section, effective the ultimate until the delegation RCRA, authority of the Railroad Commission of Texas, to prevent pollution of surface water, subsurface water, and state of the commission shall adopt the surface rules of the orders may issue the permit relating to drilling, exploratory wells, oil, gas wells, or purpose of the connection with them and the production of the oil, gas, including activities associated with the drilling of the injection water source of the penetrative of the base for the usable quality of water, activities associated with the drilling, cathodic protection associated with the cathodic protection well of the pipeline subject to the jurisdiction of the commission, activities associated with the gasoline plants, natural gas liquid with the processing plant, pressure for the maintenance plant with the repressurizing plant, and activities associated with the underground natural gas storage facility provided with the terms natural gas the storage facility shall have the meaning set with the other section 91-173 of the Natural Resource Code. Activities associated with the underground hydrocarbon facility provided with these terms hydrocarbon and underground hydrocarbon storage facility shall have the meanings of the set of the 91-201 Natural Resource Code. The F, the activities associated with the storage, handling, reclamation, gathering, transportation, distribution of oil, gas, prior to the refining such oil with the prior to use of such gas, manufacturing, profit of residential, industrial fuel, operation, abandonment, proper plugging of the well, subject to the jurisdiction for the mission, discharge, storage, handling, transportation, reclamation, disposal, oil, gas, waste, defined in Section 91-101-1, chapter with the substance or material associated with the operation activity regulated with the Commission under subdivision 1, 2, and 3 of the section, notwithstanding the provision subsection A of the section, authority with granted with the Commission by the section does not include the authority to be adopted, enforce rule for the order to issue permit with the regarding collection of the storage, handling, transportation, profit, and disposal of waste arising out of the incident, total activities associated with the gasoline plant, with the natural gas liquid processing plants, pressure maintenance plant, pressure repressurization plants of the waste for the hazard waste of them is defined with the Ministry of the United States with the Environmental Protection Agency, presumed the Federal Solid Waste Disposal Act as amended with the Resource Conservation Recovery Act of Title 42 U.S. Standard Code 6901 and 10 sequence is amended. Acts 1971 amended lastly in 1985. Rules 91-101 Rules and Orders Text Section effective upon delegation of the RCRA Railroad Commission of the Texas of the prevent pollution of surface water, subsurface water of the Commission shall adopt and enforce the rules or the issue may permit the relating to drilling exploratory wells, oils, gas wells, and purpose of connection with them, production of the oil, gas, including authorities associated with the drilling, injection water source of the width, the penetrative of the base of the usable quality water, activities associated with the drilling, cathodic protection, holes associated with the cathodic protection well of the pipeline med, subject to the jurisdiction commission, activities associated with the gasoline plant, the natural gas liquid, the process, the plant pressure for the maintenance plants, repressurizing plants, activities associated with the underground natural gas storage provided with the term natural gas storage facility shall have the means set out with Section 91-173 Natural Resource Code. Activities associated with the underground hydrocarbon storage phase provided with the underground hydrocarbon storage facility shall have being set under 91-201 Natural Resource Code. Activities associated with the storage of the natural reclamation, gathering, transportation, distribution, oil, gas, private with the refining such oil with the prior to use of such manufacturing, private with the residential, industrial fuel, operation, abandonment, the proper plugging with the well, subject with the jurisdiction of the Commission. 4 with the discharge, storage, handling, transportation, reclamation, disposal, oil, gas, waste for the defined Section 91-101 of the subchapter of the inner sub of the material associated with the operation activity regulated by the Commission or subdivisions 1, 2, and 3 of the Section Acts 1971 amended with the Acts of 1985. Lastly, Section 91-101-1 oil, gas, waste. The section effective under the delegation RCR Authority Railroad Commission of Texas. This subchapter oil, gas, waste means with the waste that actually arises with the incident of the drilling, producing of the oil, gas, including waste arising incidental to the activities associated with the drilling, injection water, that source of the penetrative of the base for the unusable water, activities associated with the drilling, cathodic protection associated with the cathodic protection wells, pipeline subject to the jurisdiction of the Commission, activities associated with the gasoline plants, natural gas liquid, processing plant, pressure, maintenance plant, repressurization plans, activities associated underground natural gas storage facility provided with the term natural gas storage facility shall have the meanings of the Section 91-173 Natural Resource Code. Activities associated with the underground hydrocarbon storage facility provided with the terms underground hydrocarbon storage facility shall have the meanings set forth in the 91-201 Natural Resource Code. Activities associated with the storage, handling, with the reclamation, gathering, transportation, distribution of oil and gas, prior with the refining with the oil, prior to the use of such gas, manufacturing, profit of residential and industrial fuel. Okay, oil and gas water includes salt water, brine, and sludge, drilling mud with the other liquid and semi-liquid and solid with the material that does not include the waste arising out of the incidental with the activities associated with the gasoline plant, the natural gas liquids, and the process of the plant, pressure for the maintenance plant, with the repressurization plants, with the waste for the hazard waste, for the defined administrator of the United States Environmental Protection Agency, pursuant to the Federal Solid Waste Disposal Act as amended by the Resource Conservation Recovery Act of Title 42 U.S. Senior Code 6901 and 10 sequences amended, added in 1983. Amended in 85. Section 91.101.1 Oil Gas for Texas. Text of the section effective delegation of the Resource Conservation Recovery Act Authority, Railroad Commission of Texas. In subchapter oil, gas waste means with the rise of the incidental drilling of the producing the oil, gas with the incidental waste of the rising of the incident. 2. Activities associated with the drilling, injection water, well, to penetrate the base of the usable quality water. 3. Activities associated with the drilling, catalytic protection associated with the catalytic protection pipeline, subject to the jurisdiction commission. Activities associated with the gasoline plant, the natural gas liquid processing plant, pressure maintenance, repressurization plants. Activities associated with the underground natural gas facility provided with the term natural gas storage facility, should the being set out with the section 91.173 natural resource gas, with activities associated with the underground hydrocarbon storage facility provided with the terms hydrocarbon, underground hydrocarbon and storage facility, should have the meaning set under 91.201 natural resource recovery code. Activities associated with the storage, handling, reclamation, gathering, the transportation, distribution of oil, of the gas, or the prior of the refining of such oil, with the prior to use of such oil, with the manufacturing product, of the residential industrial fuel, with the oil, gas waste, includes salt, water, brine, sludge, drilling mud, with the liquid, semi-liquid, or solid waste material. Added acts amended added to acts of 1983, amended in 1985, section 91.102. Access to property records, member of the employee with the commission, property identification made to the public, the private, the property to inspect with the investigate condition relating to the quality of the water in the state, to inspect with investigation conditions relating to the development of rules or of the permits issued under section 91.101 of this code, with the money with the plan with the rule permit, with the order of the other commission examining the company with due reasonable work hours of those records of the memorandum of the business being investigated, members of the employees acting under the authority of the section who enter the establishment of the public private property shall observe the establishment safety, internal security, and fire protection rules added in Acts 1983. Section 91.101.3 application fee with the application fluid injection well permit. The applicant shall submit with the commission of the non-refundable fee with $200 in section fluid injection well means well with the pre-inflow injected fluid gas into the ground connection with the exploration production of the oil gas other than the oil gas well disposal. Well, regulated with the Commission pursuant to Chapter 27 of the Water Code, with the application for the permit of discharge with the surface well with the Chapter Commission rules other than permit the discharge of the national pollutant, the discharge elimination required for the agricultural wildlife, due to the applicant so submit with the Commission with a non-refundable fee of $300. The fee under this section should be divided with an oil gas regulation cleanup fund added to the Acts of 1985, amended in the Acts 2011, Section 91.101.5 groundwater protection requirement. The Commission shall adopt the rules established groundwater protection requirement. The operation with the jurisdiction of the Commission include the requirements relating to the depth of the surface casing of the wells, added to the Acts in 2011. Section 91.101.7, the location of certain pits. The Commission of the rules shall establish standard governing permissible location of the pits used for the commercial oil, the gas disposal fields. The rules must include the history flooding of the 10 years preceding the construction of the pit, with the factor in determining whether the proposed location of the permit is permissible, added in Section Acts 2021. Section 91.102 with additional personnel of the Commission to direct for the employee the additional personnel necessary with the administrative subject that related to the laws, rules, orders adopted with the Commission Acts added 1977, amended 1983. Section 91.103, the person required with the execute the bottom of the letter credit with the cash deposit with any person included with the firm of the partnership with the joint stock with the association, corporation, or other organization required to file organization report with the Section 91.142 for the code shall execute the file with the commission of the bond letter of the credit and cash deposit Acts of 1977, amended in 2004. September 2, September Section 91.104 of the bond letter with the credit with the cash deposit with the well specifically plugging with the include insurance bond with the commission shall be required with the bonds with the letter of the credit cash deposit with the bill with the commission to provide the subsection B. A person required with the file with the bond letter with the credit with the cash deposit with the Section 91.103 with the inactive the operative with the one or more wells with the time of the filing renewing with the organization report required with the Section 91.142 with the file with the individual bond with the provided under Section 91.104.1. Letter of the blanket provided with the Section 91.104.2, or the letter of credit of the cash deposit with the same amount with the credit with the individual bond under Section 91.104.1, or with the blanket of the bond under Section 91.104.2 of the person required to file with the bond letter of the credit with the cash deposit under Section 91.103. operates one or more wells considered with the have met with the requirements of the well with the bore with the include of the well specific plug with the insurance policy as approved with the Texas Department of Insurance with the name of the state of the owner of the contingent beneficiary of the policy with the name of the primary beneficiary of the agreement of the policy with the specified well bore and the fully prepaid with the contained with the cans with the provided with the policy continue with effect until the specified the well bore is plugged, provided the benefits will be paid for the not before with the specified well have been plugged within accordance with the commission rule with the fact with the time of the plugging provide benefits equal greater to the rate of the amount equal to $2 each of the foot with the well with the determined demand with the specified with the commission for the specified well with if specified with the well by any well regardless of whether the well is producing oil or gas, the amount required within the commission rule of the bay whether it is not producing oil or gas. If specified with the well of the offshore well, with regardless of whether the well is producing oil or the gas, the amount required with the commission rule of the offshore well that is not producing oil or gas, but the payment otherwise due under the policy for the plugging the well. Acts 1977 amended in Acts 2005, Section 91-104-1, individual bond. Person required to file with a bond letter of credit for the cash deposit of 91-103. Operators of one or more wells may follow the bond equal amount equal to $2 each for over the well, depth of each well, but notwithstanding subsection A of the commission for the rule shall set amount for the bond for the operator one or more bay with the offshore well that the responsible of the amount to exceed the amount provided subsection A of the well when calculating under subsection A of the amount with the bond with the person operating with the more of the well with the required to file with the commission should exclude the well with the well bore with include the well specifically plugging the insurance of the policy described in section 191-104C. In the conclusion of the bayshore offshore well with the bores include the well specifically plugging insurance as described in section 91-104C with the calculation of subsection B with the amount with the bonded operator of the one or more with the bay offshore well required to file with the result with was included the amount with the bond with what otherwise be required. The rules must provide with the exclusion of the well for the calculation added in the Acts for the 1991 amended within 2005. Section 91-104-2 blanket record bond of a person required for the bond for the bond letter of credit cash deposit 91-103 file new may file blanket bond to cover all the wells which of the bond letter of credit cash deposit required. If the person operates for 10 or fewer wells shall file with 25,000 blanket bond. Person who operates more than 10 but fewer than 100 wells shall file with a $50,000 blanket bond. Person who operates 100 or more wells shall file with a $250,000 blanket bond, notwithstanding the subsection commissioned by the rule. Shall set the amount of the bond operated by the offshore with the responsible amount with exceed the amount provided with the subsection A 1, 2, 3 and applicable. When recalculating the number of the operators well with the purpose of the subsection A with the commission shall exclude the well with the well bore, include with the well specific plugging issue with the policy described in 91-104C. If the inclusion of bayshore offshore well was bore included with the well specifically plugging insurance policy that's described in section 91-104C with the calculation of subsection B, the amount of the bond operator with the bay offshore well required to fill would result in the increase of the amount of the bond with the otherwise required with the rules must provide with the exclusion of the well with the calculation act of 1991 amended within the 2005 91-105 bond conditions. Each bond required with the section 91-103 shall be the condition with the operator will plug with the banding with all of the well with control of the state, abate with the cleanup of the pollution associated with the operator over the gas code, actively covered with the bond with the accordance with the law of the state of the permits, the rule of the ordinance of the commission. Section does not apply with the well specific plugging insurance policy described in section 91-104C Acts 1977 amended in 2005. Section 91-106 the execution of the bond. Each bond should be executed with the corporate security authorized to do business within the state shall be renewed with the continued in effect until the conditions have been met and relieved authorized by the commission. Acts 1977 section 91-107 the new bond with letter of credit with the cash deposit with an active if an active and inactive well with transferred solved with the same if the operator of the commission requiring with the requiring party requiring with the well to file with the need bond letter of credit cash deposit with providing section 91-104B with the final security with the prior operator will continue with the required to remain with the effect of the commission may approve transfer operatorship until the new bond letter of credit cash deposit with the provided commission determines the bond letter with the credit with the cash deposit with the previously object with the commission person acquiring with the well comply with the subchapter A. Transfer over the well one and either the other under the common ownership of the transfer purpose of the section. The section does not apply over the well bore with the included wells specifically the plugging insurance policy and described in section 91-104C. Acts 1977 amended in Acts 2005. Section 91-108 the deposit of the use of the funds subject to the refused refund provision 78 section 91-109-1 applicable to proceed with the bonds of the other financial security required to assume with the chapter of benefits as well specifically plugging insurance policy described in 91-104C but they are paid to the state with the contingency beneficiary policy with the deposit of the oil gas regulation cleanup fund with the notwithstanding section 81-068 with the 91-113 Maybe you the actual welding, plugging, surface remediation acts of 1983 amended in 2005 and 11. Section 91-109 financial security over the person involved with the activity other than operation of the well. The person applying for the acting over the commission with the permit of the over the handle of the tree, the reclaim of the disposal of the oil, gas, may be required by the Commission to maintain the performance of the other form of the financial security condition of the permits for the operative of the clean storage, handling, treatment of reclamations, disposal of the site of the accordance with the state law of the Commission rules. Permit the operator of the state, but however the section does not authorize the Commission require the bond other form of the financial security for the water disposal of the pits, for the emergency salt water storage pits, including blowdown pits, calculating pits, or skimming pits for the provided such as the pits for the connection with the operating with an individual oil gas leak subject to the form. Subject to refund provision, section 91-1091, proceed with the bond. Any form of financial security required in the section shall be placed in the oil gas regulation cleanup on each of the bond other than the financial security should be renewed and continued in effect until the conditions have been met with the release authorized by the Commission. In addition to the financial security requirements, subsection A, the person required to file with the bond letter of credit in the cash deposit, section 91-103, with the law of the activity, the ownership of the operated wells must file with the bond letter of credit as deposited at the time of the filing, renewing an organization report required in section 91-142 with the required filing schedule. Or no bond letter credit over the cash deposit if the person local, the distributor, can come with the gas market for the crude oil, the nominator first purchase of the well, serve the company, serve the company, salt water haul, the gas numerator for the gas purchase of the well, plug of the bond with the letter of the credit for the gas deposit of the amount not exceed $25,000 and personally involved with this activity not associated with the ownership of the operation of the well. Now listen, subdivision 1, a person engaged with more than one activity of the operation, including the well operation for the which of the bond and letter for the credit, such for the deposit of the well for the subchapter is not required to file separate bond letter of credit, the cash deposit for each of the activity of operation for the person is engaged for the person is required to file with the bond letter of credit. Cash deposit only the amount required for the activity operation on the which for the person engaged for the bond letter of the credit. Cash deposit for the greatest amount required for the bond letter. Credit cash deposit for the file covered over the activity operation for which the bond letter of the credit and cash deposit required under the subchapter Acts 1985 is amended and last amended in 2011. Subsection 91-1091 refund of the Commission shall refund the perceived the bond letter for the cash deposit required under the subchapter of the conditions covered the perceived the collective the corrective the administrative civil and criminal penalties relating to the condition are paid the Commission for the being reimbursed all of the cost of the expense for the incurred of the Commission in relation for the condition amended to Acts 1991 amended and added to the Acts 1991 amended in Acts 2005. Section 91-110 for the oil, the gas waste reduction and minimization. With the incur of the reduction, minimization of oil, gas waste, the Commission shall implement the program to provide operative with the trained technical assistance for the oil, the gas reduction, minimization, assist to operative with the developing oil, gas waste reduction, minimization plans. The rule establish an incentive for the oil, gas reduction, minimization. Added Acts 1991. Section 91-113, investigation assessment of the cleanup commission if the oil, gas, or the other substance for the material of the regulated the commission under section 91-101 are causing likely to cover the pollution or surface or subsurface water of the commission, whether it's employed with the agency, may either the oil of the gas regulation cleanup fund to conduct the site investigation environmental assessment with the control of the cleanup of the oil of the gas with the other substance of the material if the reasonable person have failed to refuse the control of the cleanup oil of the gas waste of the other substance of the material that after the notice of the opportunity for the hearing responsible person is unknown, cannot be found, with no asset for which for the control of the cleanup of the oil, of the gas waste, the substance of the material, the oil of the gas waste, over the other substance of the material, covered the pollution surface of the surface, subsurface water, for the purpose of this section, reasonable person remains for the protector, the operator of the other person required with the law of the adopted with the convention valid order for the convention to control of the cleanup of the site of the clean up the oil and gas waste of the other substance material of the convention with the employee of the agent's property identification may enter the land either for the purpose of conducting site investigation, environmental assessment, or controlling the cleanup of the oil, gas waste of the other substance of the material in this section. To conducting site investigation, environmental assessment with the control of the cleanup of the oil, gas with the other substance of the material of the commission under the selection if it does not prevent the commission from seeking the penalties of the relief of the violation of the law, any of the person required by the law with the rules adopted by the commission valid order of the commission control cleanup of the oil, of the gas waste, or the substance of material. Commission of its employee is not liable for the damage arising act of the mission, but the act of the mission with the part of the good faith of that three character section. If the Commission conducts the site investigation, environmental assessment, control, cleans up the oil, the gas, the waste, of the other substance material under the section of the Commission, with the recovery of the action for the incurred of the Commission from any person who required by law with the rules adopted by the Commission, the valid order of the Commission, with the control of the cleanup of the oil, the gas, waste, for the other substance material of the Commission by orders required of the person reimbursed for the Commission of those caused for the request for the Attorney General file suit with against for the person to recover the cost for the request for the Commission for the Attorney General may file suit with the enforcement order if the Commission over the section suit under the subsection may be filed with the competent jurisdiction of the Travis County with the cost recovered in the subsection shall be deposited into the oil, the gas regulation cleanup fund acts added in the Acts 1991 amended with the Acts 2011. Section 91.113.1 Risk Assessment Standard of the Commission with the rules may establish the risk assessment guide for the conducting site investigation environmental assessment, showing cleaning up the oil, the gas, with the other substance material of the rules adopted under the section provided with the during relation with the actual potential risk of the site with the screen with the contamination site with identified with the pose of the risk. 3. Develop and clean up standard of the base of the contamination level to protect the human health of the environment. 4. Establishing the reporting mechanism for informative commission for specific remediation activities added Acts 2001. Section 91.113 2 for the prioritizing high-risk well. The Commission rules should develop the system for identifying and abandoning well of the post high-risk contamination surface of water with the groundwater, periodically testing high-risk wells, conducting fluid well level tests with the necessary pressure test to give priority to the plugging of the high-risk wells with the compromised casing. Section 91.114 acceptance for the organization report for the application for the permit and approval of the certificate compliant with the revocation except for the provided subsection D for the Commission may not accept the organization report or under the Section 91.142 for the other application for the permit under Chapter 85 of the Chapter 26, 27, and 29 Water Code that approve certificate compliant with the 91.701. Organization submitted with the report application certified with the applicant violated stated as Commission rule with the order license certificate the permit related to the safety, the prevention, and control of the pollution. Person who holds position ownership of the control of the organization within 17 years preceding with the date of the report application for the certified for the withheld over the pollution of the ownership of the control of the other organization during the period with the ownership of the control of the other organization. Violated statute with the Commission rule with the order license the permit certificate related to the safety, prevention, of the control of the pollution organization committed with the violation. Final judgment, the final administrative order finding of the violation have entered again for the organization. All the appeal for the exhaustive of the Commission for the organization has entered within the agreement with the relating to the alleged violation, regardless of whether the person names appear or is required to appear with the organization report required in Section 91.142 of the person hold of the position, ownership of the control of the organization, if the person is the officer, the director of the organization, general part of the organization, owner of the sole prioritization, owners of at least 25% of the beneficial interest for the organization, trustee of the organization, 2. The person has determined the final judgment, the final administrator of that order of the exertive of the actual control over the organization. Commission shall accept the report application and approve of the certificate if conditions for the constitute the violation of the corrective that are being corrected in accordance with the schedule of the Commission for the organization level agreed. All administrative, civil, and criminal penalties clean up the relating of the cost of the incurred for the state relating to these conditions are paid, the rate of the being paid with accordance with the payment schedule for the Commission for the organization have agreed in the report application for the certification with the compliance with all the requirements of the law and the Commission rules. If the report application is rejected with the certificate is disapproved with the under the section, Commission shall provide with the organization written statement explaining with the reason for the rejection of the disapproval. Notwithstanding subsection A, with the Commission may issue pay with the organizational describe subsection A for the term specified of the Commission. If the permit is necessary, remedy the violation of the law of the Commission rule of the fee tendered with the connection with the report with the application rejected under the section of the non-refundable. If the Commissioner is prohibited in subsection A from accepting the organization report with the application for the approval of the organization certificate would be prohibited from doing some subsection of the organization submitted with the report application certificate. Commission after notice opportunity for hearing order may revoke the organization report filed under section 91.42 with the permit issued for the organization under the chapter 85 section chapter 26, 27, and 29 Water Code with the certificate appliance under section 91.701 order under section H for the shall provide with the organization a reasonable period of the time comply with the judgment order of the finding of the violation before the revocation takes effect. J. On the revocation organization report, the organization may perform activities under jurisdiction Commission under title chapter 26, 27, and 29 of the Water Code except for the necessary remedy the violation of law of the Commission rule of the authorized by the Commission. The Commission may not revoke the organization report for remote board permit and certificate compliance under the subsection H for the fine with the organization has filled with the condition set out in the subsection D. Determining whether or not to revoke the organization report with a permit with the certificate compliant with the subsection A for the Commission shall consider the organization history of the previous violation, seriousness, previous violation has with the health and safety of the public, and demonstrate for the good faith of the organization, revocation of the organization report permit with the certificate does not relay leave the organization able the existing future of the duty of the under law of the permanent condition, protect surface with the subsurface of the water with the pollution, properly dispose of the oil, gas, and waste, clean up unpermitted discharge of the oil and gas waste. Acts added in 1991, amended in 2007. Section 91-115. Person lien of the equipment and store of the hydrocarbon drill cutting with a reasonable fraud. Person failed with the cleanup of the site of the facility with the cleanup of the oil with the gas with the operation commission jurisdiction on number 4. The day of the site of the facility required for the cleanup by the law with the rules adopted with the order issued by the commission of the state have the first lien with the superior of the all pre-existing subsequent lien for the security interest with the reasonable person interest. Any hydrocarbon drill cutting store of the site of the facility and any of the equipment that is located in the site of the facility with the reasonable person in connection with the activity generated in pollution. Lien is amount with the total cost of the cleaning oil, gas, waste, with another substance from the site of the facility. The right of the day of the site of the facility is required by law, rule, order of the commission to be cleaned up. The commission may foreclose without the lien. Entering the contract for the cleanup of the site of the facility of the commission is not required to give the notice for the opportunity to the hearing for a hearing to subordinate lien holders under performing entry into a contract and clean up the site of the facility. Lien is extinguishing in the site of the facility is cleaned up with the quorum of the commission rule with any of the person before the commission any of the contract to clean up the site. So the lien extinguished as the door of the hydrocarbon drilling, cutting for the items of the equipment that lawfully remove the any of the personal operator for the non-operator according to the lien, lease for the judgment, written contract for the security agreement before the commission enter for the cleanup contract for the item of the equipment that may not be removed with the abandoned site of the facility with the removable cover the relief of the substance that may cover the pollution and level the substance is lawfully disposed of. Half of the equipment stored hydrocarbon drill cutting subject to the lien under the section are presumed to have been in the band of the day of the commission enter into the contract to claim the up to site with the facility with the equipment and hydrocarbon drill cutting located with the commission that is disposed of the band of the equipment is stored hydrocarbon in accordance with the provision section 89, 085, 86, and 87 with the disposition well site of the equipment is hydrocarbons. F2. Commission may dispose of the band and store of the drill cutting with the contracting with the person treating the drill with the cutting with the site with the facility with the subsequent beneficial use with the selling with the treaty with the drill with the cutting with the public auction with the public and private sale of section 89-085C1, 89-086 and 87 apply with the deposition with the drill cuttings in the subsection with the same manner with these sections apply with the disposition of hydrocarbons. In this section, drill cuttings have the mean assigned with the sections 123.01, reasonable person have the mean assigned with the 91.113, treat means of the manufacturing, mechanical, thermal, chemical, probably the other size and shape of the diluting of the sorting, the lien provide with the sections relate with the hydrocarbon subject for the inferior of the any lien, favor the shape of the text as such for royalty payments, aided the Acts for 1993, amended in 2021. Section 91-116, no the commercial surface disposal facility, permanent application for the section commercial surface disposal facility means for the facility for the primary purpose of the provide with the compensation surface disposal of the oil field fluid, oil gas with including land application for the treatment and disposal of the person filed with the application for the permanent with the commercial surface disposal of the facility shall publish the notice of the application for the accordance with this section. Notice must occur with the day of the application was filed with the description and location of the site with which the application was made with the county in which the site is located with the name of the original survey, the abstract name, number, the direction of the distance with the nearest municipality, the name of the owner of the site, with the name of the applicant, the type of the fluid, the way to dispose of the facility, dispose of the method, perceive the protesting the application of the notice of the must be published at least once a week for the 2 consecutive weeks of the first publication occur with no later than the day of the application filed, but no later than 30 days after the day of the application filed. A newspaper, the general circulation in the county with the proposed disposal of the void occur out of Acts 1999. Alright, section 91-117, public information here with the application for the commercial surface disposal of the facility, in section of the commercial surface disposal of the facility, that meaning assigned with the section 91-116. Commission may be the hold of the public meeting to receive the public comment with the application for the commercial surface disposal of the facility with the commission. The term of the public meeting is in the public interest. The meeting must be held in the county in which the proposed facility will be located. Acts added in 1999. Some Okay. Subchapter E, Books, Records, and Reports. Section 91-141, Book Records. Owners, operators, oil, gas wells shall keep the books show accurately amount of the unsold stock, amount of the promotion money paid, the amount of the oil, gas received, the disposal of the price with which the oil was sold, received for the sale of the transfer of the lease for the other property disbursement made with the connection with and for the benefit of the business. Books shall keep on the inspection of the commission and the credit of the representative of the commission, stockholder, shareholder of the royalty, owner of the business, or as operator of the oil, gas well shall with the report with the information commission for the information required of the commission to do so. Acts 1977. Section 91-142 of the report to the commission person, firm, the partnership, joint stock action, corporation, or other domestic foreign organization operating hold of the territory with the state of the acting with the principal agent for the another purpose of performing operation within an area within jurisdiction of the commission shall file with immediately with the commission the name of the company and the organization, post office address of the company and organization, the pioneer of the company of the organization was organization, names of the post office address for the trustees of the company of the organization, name and unique identifying number such as the driver's license number, the post office address for the officer of the directors, circulate for requiring subsection B of the section, the name of the director of the president, agent, and foreign non-resident entity listed in subsection A shall not maintain the designated resident agent with the process notice for the determinate and required or permitted by the law to serve the pound of such that need to be served, and any such event need required with the terms of the section, maintain with the designated such report agent shall fail to do so, then in such an event with the organization report required to be filed, commission is not valid. Failure by such entity listed in subsection A of the exchange for the such profit demand shall render the organization report invalid. The commission shall require the entity described in subsection A of the section to refile an organization report according to the schedule re-established by the commission. F. The entity described in subsection A does not maintain an on-file with the commission organization report with the financial security is required by the chapter. Entity must not perform operations under the jurisdiction of the commission except administrative remedy, violation of the law, commission of the rules authorized by the commission, and commission of the written notice may suspend and permits and beheld with the A with the certification of compliance approved with the under subchapter F, sub P. An organization report filed with the under subsection may be accompanied with the following fee for the operating for the more than 25 wells of $300, for more than 25 but more than that, no more than 100 wells, 500, operating for the more than 100 wells, 1,000, operator one or more natural gas pipelines classified commission $225, for operator one or more service activity facility that does not operate any of the wells is amount determined by the commission not less than 300, more than 500, for an operative of one or more liquid pipelines classified by the commission who does not operate any well within any amount determined by the commission but not less than 425 or more than 625, for operator one or more surface activities facility liquid including liquid pipeline with classified by the commission who operates from the one or more of the wells of the amount commission determined commission based on some of the amount of provided in applicable subdivision subsection but not less than 425 or more than 1,125 for the debt not currently performing operation under the jurisdiction commission $300. H. To enable the commission to better predict the state of the breach over the entity with the described in subsection A with the affiliate with respect to the entity performing operation for the jurisdiction of the commission for the file for the federal bankruptcy protection shall give the written of the commission for the action of the submitting of the official general counsel no later than 30th day of the after for the date of filing acts of 1970 amended the acts 2007 and 91-143 false application of the report of the document tampering with the gauges. Person may not make so prescribed the application report with the other document required with the permitted to file with the commission for the provision title 102 of the provided civil statute of the taxes 1925 with the amended with the include the provision of the code of the formal include the title with the knowing with the application for the report with the other document false and untruly material fact aiding the shift of the procurator counsel for the advice of the preparation presentation any of the application of the reports of the documents of the fraudulent false incorrect material matter known to them to be fraudulent false incorrect with the many material matter knowing simulated with the falsely with the fraudulently with the execute with the such for the application for the report with the other document knowingly procuring these applications of the reports or other documents falsely fraudulently executed advised add and combined with these execution only render inaccurate with any of the modern device required to maintain with the commission rule of the order permit a person commits of an offense of the person violates subsection and offense of the section is felony punishable with imprisonment in Texas Department of Criminal Justice for the term not less than 2 years, no more than 5 years. Fine not more than $10,000, both imprisonment over the fine other than penalties prescribed in Title 102 of the Provided Civil Statute for the Texas 1925 as amended, including provisions of the code formally included within the title overlap the offense for that. Also punishable with the under section penalties prescribed in the section shall be the addition with the other penalty with no application report with the other document required with the permitted to file with the commission under Title 102 with the provided civil statute with the 1925 the amendment to include the provision code formally included in the title may be required to be the under oath verification acknowledgement and information the commission may impose administrative penalty in the manner provided in section 810531 through 810534 on a person who violates the section amount of the penalty may not exceed $1,000 each violation. Acts 1977, amended Acts 2000. Subchapter F, underground natural gas storage conservation. We can cut the tape there.